This is an ad hoc committee that we've called, and I want to lay down some ground rules. Number one, this is not an official committee hearing. I have no authority here other than to try and be the facilitator for the voice of the people who have come here this morning. Allow witnesses to come forward, and our goal this morning is to talk about some of the issues that we've had in the judiciary. It's not to impugn the reputation of any judges or any of that process. This process is merely to say, is the system working? And then if it is not working, where are the areas that it's not working? And then hopefully come up with some recommendations for some solutions that we can bring forth some legislation that would begin to address those issues. I also want to introduce Representative Mary Liz Holberg is here this morning as well. We've sent out invites to other legislators. There's also committee hearings going on this morning. I've talked to a number of them, and they are committed to these committee hearings. You'll probably see them come in on a kind of an irregular basis as they're able to get here. One of the goals of the committee here this morning is that we would put these recommendations forward, identify the problems that we're having, and then put forth a recommendation that we can put to the other legislators who are not able to be here, and then generate some legislation that addresses those specifically. And then it would be the job of the citizens here and those who are not able to be here to contact your representative and ask them to support that legislation as it goes forward. I also want to just say, this is a great group of people here. I appreciate you taking the time this morning. Obviously, there's points of interest here. The goal is that people would have a voice in this process. We'll see how that goes. We're going to go from 9 o'clock until 11 o'clock. And first 5 testimonies are fairly constructed. We're going to have some testimony. We're going to have, after that, some recommendations for adjudication for some of those processes, and then if we have time after that, then we may take some testimony from the audience itself. Again, I would ask that you not impugn the name of judges. Our goal, this is not a witch hunt. This is not going after judges in particular. This is about the system. This is about, is the system working? If it's not, what's broken? How do we fix it? So with that, we have an agenda, and if you haven't received an agenda, they're on the table here. And please come up and grab one. This is not a super formal get together. However, we want to make sure that everybody's rights are respected here. If anybody feels the need to get up and head out for logistical reasons, please do that. However, if things start to get out of hand, I would ask that those around would take charge. You're out? Can I get some more made? Inside the door. Yeah, that's fine. Andy, here. Hey, Andy, could you make a couple more copies of these?
Andy, do you want a clean one?
We're having some more copies made here. I think that there's probably, sorry for the mix-up on the room number here. We wanted a room that would facilitate a large number of people, and the other rooms at the state office building were booked up this morning, so we weren't able to use those. But this is okay. This room will work fine. So having said all that, I'm going to ask, we'll just proceed here. We have Greg Worsel is here to start out the presentations, and let me just say that Greg has been a huge champion for our judicial system and our legal system. He is a gentleman that went before the Supreme Court and argued the Republican Party versus White and opened up the records of the judicial side so that now we as citizens have an opportunity to see how judges ruled on that particular provision. And Greg, if you wouldn't mind, just give your name for the record and proceed.
Sure. The name is Greg Worsel. Worsel is W-E-R-S-A-L. I'm an attorney. I've practiced law for 29 years in the state of Minnesota. I was a former candidate for the Minnesota Supreme Court. I was the lead plaintiff in the case of Republican Party of Minnesota versus White, which dealt with judicial elections that went to the U.S. Supreme Court. I am currently a candidate for the Minnesota Supreme Court for the elections to be held in 2010. And I am currently suing the state of Minnesota for additional judicial election rules that were created by the Minnesota Supreme Court after we won in front of the U.S. Supreme Court. They just create more rules, and we just have to churn out more litigation. I was asked today to talk about the judicial system, and I would start by saying the judicial system is out of control. And it's out of control because we have no accountability in the system. There are only two ways to get accountability into the system that I can see, and the first is elections. And the election system we have does not work. It doesn't work for a variety of reasons, not the least of which is the word incumbent on the ballot. And I want to give you an example of how bad that is. In 50 years, not one incumbent has lost an election to the Minnesota Supreme Court. And since its inception, since the court was created, the Minnesota Court of Appeals, not one incumbent has lost a seat in a contested election. So we have elections that occur again and again, the incumbents always win, and the system simply doesn't work. The Board on Judicial Standards is also a joke as far as I'm concerned. It is ineffective, its processes are secret. As someone who's actually submitted complaints, I can tell you how ineffectual you feel when the entire response you get back from the Board on Judicial Standards is, we've taken care of it. And you never know what's happened, if anything has happened. Most attorneys I know will not file a complaint with the Board on Judicial Standards against a judge because they're afraid of retaliation by the judges, and that is a real problem. And the Board is also populated by many attorneys, and that's one of the reasons the Board doesn't function, because those attorneys also feel that they are under the judge's thumb. Because we have no accountability, and we haven't had accountability for years, we've got a growing problem. The problems are judicial incompetence, judicial abuse, and maybe judicial corruption. I want to talk briefly about judicial incompetence. Almost all the judges in Minnesota, it's well over 90%, are appointed by the governor. And frankly, the governor appoints his friends. And frankly, many of those friends are not intellectual giants. And so we have a lot of mediocre judges. What that means is that we have an instance, for instance, we have the Minnesota Supreme Court, where not one judge on the Minnesota Supreme Court has been a prior trial court judge, district court judge, prior to their appointment. They have no experience on the trial courts. Yet all the cases they're getting before them, they're reviewing trial court decisions. So it just doesn't make any sense, the system we've got. 90% of the caseload in front of district court judges are criminal law and family law cases, and yet many of the governor's friends are corporate lawyers who've never handled a criminal or divorce case in their lives. And that incompetence is then reflected in their decisions. Judicial abuse is the second problem. It takes many forms. And I'll again just give you a couple examples because I know there are going to be many speakers who are going to talk directly about judicial abuse in their cases. But I want to explain a couple of the cases I've seen. The state, several years ago, the legislature created sentencing guidelines. I've practiced criminal law for 29 years, and I'm going to tell you that the sentencing guidelines are commonly ignored in our courts. Another problem is bail guidelines. Just a few years ago, several years ago, the legislature created a rule that said that repeat DWI offenders had to either be given $10,000 bail or be put on an alcohol censor. Yet you can go into courthouses throughout the state and find that that rule is ignored. So what happens is that...
excuse me, did you say the legislature created a rule? Or are you saying it was a law?
The legislature created a law.
Okay,
Excuse me,
thank
a
you.
law. And then, let me give you an example of what happens. The best example is out in Wilmer. The prosecutors in Wilmer looked at the court rules and they said, well, look, we've got a right under the court rules to strike a judge from hearing the case. It's in the rules. Supposedly everybody should be able to do it. So they had a certain judge there who wouldn't follow the guidelines for either bail or an alcohol censor on repeat DWI offenders. So they would routinely strike that judge. You know what happened? There was immediately an action, and the Minnesota Supreme Court was threatening the county attorney's office that with sanctions, that if they continued to persist in filing to strike that judge, that they were going to go after the attorney's license. Now, what we have is the judiciary telling the executive branch, because the county attorney is part of the executive branch, how they should handle their office. And this is a threat to the people of Minnesota, because if we don't have effective county attorneys, we're going to have problems.
I'm sorry, Mr. Worsel. Let me just get clarification on that. So the county attorneys said that the judge was not issuing accordance to guidelines, and they were striking him from the list, and then the Supreme Court came back and basically said you can't do that or we'll come against his license?
But they'll come against the attorney's license, the prosecutor's license. That's correct. And again, the court rules say you can strike a judge without giving a reason. The prosecutor does not have to give any reason to strike a judge, just as the defense have a right in a criminal case to strike a judge without stating a reason. But again, because it was obvious that there was a pattern, they went after the county attorney. And again, I think this is an abuse of judicial power. Judges have the power to arrest people and throw them in jail. And I still remember to this day in Hennepin County watching a judge who ordered the bailiff to go outside and arrest construction workers who were doing work on the court building. He felt that they were being too noisy. He had earlier sent the bailiff out there to tell them to knock off the noise. Well, they're using jackhammers for they're trying to do a construction job. That's why they're there. The judge had the bailiff go out, arrest them, bring them in, and he threatened to hold them in contempt if they continued to make noise. Now, we don't hear about these problems because as an attorney, who's going to file this complaint? The attorneys are scared to file these complaints. My point to you is judges have enormous power. I have seen judges who are prejudiced, female judges, one, who hates men. It's quite obvious if you've ever been in front of her. I have seen judges who are sexist, men who demean women who appear in front of them, especially women lawyers. I have seen judges whose every other word was a four-letter word that I can't repeat here. I have heard of judges who have changed court transcripts to hide their abuse. Now, that's the kind of abuse we're talking about, and again, others are going to give other instances of that. But we've got the final category, which is judicial corruption. And I want you to understand, I kind of doubt that anyone's going to say that today, specifically, they can point to an instance of judicial corruption. But I want to give an example that happened to me several years ago. I had discovered that Justice Page on the Minnesota Supreme Court had a charity that he ran, and in addition to being a judge on our state Supreme Court. The charity provides scholarship to students. I'm not going to say that the charity isn't useful, isn't beneficial to the people of Minnesota. But what I will say is, before he became a judge, that charity existed, and almost no money flowed into that charity. And after he became a judge on our state Supreme Court, thousands and thousands and thousands and thousands of dollars was flowing into that charity. And if you looked at who the contributors were, because they have to file documents with the state, you find out that many of those contributors were attorneys and law firms that were then appearing in front of our state Supreme Court. Justice Page was not recusing himself in those cases. I filed a complaint with the Board of Judicial Standards, but to the best of my knowledge, nothing happened. The charity still exists and the money is still flowing. There was one change made. Justice Page was actually filing on behalf of the charity documents with the board that governs charities in the state, and he was signing at the bottom who was getting how much money. So it was obvious he knew who was getting thousands and thousands and thousands of dollars. After my complaint, he was no longer signing those documents, but the thousands of dollars were still coming in, and for all I know, he's still able to make requests for that money, etc. This is something that needs to be investigated. There's also a problem that has been talked about somewhat. I think Dale Nathan, who's going to address the committee later, is that the Code on Judicial Conduct allows gifts of up to $150 to be given to a judge, and that the Code of Judicial Conduct doesn't see this as a problem. But what you're going to see is that a lot of the people giving those gifts are lawyers who are appearing in front of the judges. And to the best of my knowledge, no gift can be given to a member of the legislature. I don't know how we can allow this to continue. There's going to be a variety of solutions, I think, that are going to be discussed today, including redesigning the board on judicial standards, redesigning, taking a good hard look at how to make elections work, whether the word incumbent should be on the ballot. But one of the things that I'm not sure is going to be addressed that I would like to just to mention is that right now attorneys are scared to death because of their licenses are controlled by the judges. And if you want to have a system that works where the attorneys can actually come in and give you examples of what's going on and not be afraid, we need to change that licensing. We need to have attorneys licensed by some other branch of government, whether it's the Department of Commerce, the Department of Labor and Industry. It has to be something other than the courts. Thank you very much for your time.
Thank you, Mr. Worslow. I appreciate your testimony. Next, we have Joe Clark. Thank you. Yep.
Good morning.
Thank you, Ms. Clark. Would you just give your name and proceed, if you would?
My name is Jill Clark. I'm an attorney licensed to practice in Minnesota, at least as of today I am. We'll wait and see if I still am after this hearing. I am an attorney with approximately 20 years of experience. I have litigated in many venues. I do civil cases in federal court. In about the year 2000, I began doing a lot of pro bono work, vigorously defending people of color in state criminal court. Frankly, I could not believe the way I was treated by numerous judges when I began to vigorously defend African Americans. That list is so long, I'm going to leapfrog over it, but I want to let these members who took the time to come here today and listen to, obviously, many people with concerns, let you know that I am available later. You can call me. I can come over. We can chat. I have numerous documents. I have a lot of knowledge. I want to start by saying that there are many good ethical judges. In no way do my comments today impugn the entire bench. There are judges who care. There are judges who are moral and upright. And there are judges who will do the right thing with pressure from other judges to do the wrong thing. Those people know who they are. They don't need my laud and praise, but I want to acknowledge them. There are numerous problems in the judiciary. I, so to speak, retired in the year 2000, and my motto was kind of, you know, the way that comedian used to say, take my wife, please. If I got under pressure, felt under pressure, I'd say, take my license, please. Put me out of my misery. Keep me from practicing law anymore. But the notion in my head was I had created a platform of freedom for myself, because if I didn't fear them taking my license, I didn't fear them. And I began to be a lawyer who would speak out with due diligence about the facts and due diligence about the law, but nonetheless speak out on behalf of my clients who are encountering problems with the way that the judge was handling the case. These things took many different shapes and sizes, these problems. Ex parte communications, flagrant bias in favor of one party or against another, documents removed from an official court file with all evidence tending towards the judge being the one who made that decision. The documents would have helped my clients, but more importantly, they would have gotten the judge in a lot of trouble. I have had cases where, with all due respect to everyone involved in the system, we proved that a district court transcript, state court transcript was inaccurate. And it wasn't just any old inaccuracy. When I began vigorously defending people of color in state criminal court, I came flat up against a system that allows police to criminally charge their victims of assault, victims of police misconduct in state criminal court. And it is my belief, with the protection of the First Amendment, that there are judges that help them do it. Not all of these judges, but judges that let police misuse the state criminal justice system to protect police from civil or criminal liability. This is extremely severe. Right now I represent a woman who went to the hospital to report that she was raped by two on-duty uniformed Minneapolis police officers. The Minneapolis Police Department, in its infinite wisdom, issued a press release saying that she'd made a false statement, and guess who's being criminally charged? The woman who was raped. And I've seen the evidence in the case, and the evidence suggests highly not only was she raped, but that there's some kind of cover-up involved. Those kinds of things could not continue but for the help of certain state court judges. Some of it is probably fear. Some of it is probably fear that this groupthink, this culture, cannot be changed. What if I step out? There are probably judges who live in fear of stepping out and speaking the truth, but nonetheless, these things go on. So getting back to this transcript, there was a transcript in which my young African-American client was saying something like, and I'm not quoting it exactly, but something like, everything in the police report is true. I don't have a lot of young African-American 24-year-old clients who would say any such thing in court, either using that language or agree that the police report is true. In this case, this individual had a record of making complaints of police misconduct and speaking out against the police. We asked for an audio tape of that hearing to check the accuracy of the transcript, and we were shut down. We asked repeatedly, and we were shut down. We were told different stories. When we asked the court administrator, we were told, well, it belongs to the court reporter. Well, what public record belongs to a private individual? Then we found an order signed by the chief judge without any process, essentially legislating that all audio in Hennepin County is the property of the chief judge. Again, that's not even a constitutional officer. One judge who's elected to a single seat in Hennepin County cannot hold and own and control public property. We did not get audience. We did not get assistance at the district court. So we had no choice but to file an action in federal court. This is not the preferred course of action. The federal courts really don't have time to clean up the problems with the state judiciary, but we determined that it was our only avenue at the time. We ended up having to sue 2 court reporters and the district court administrator and the chief judge, but with the assistance of the Attorney General's office, we did finally hear that audio tape. And in fact, our hunch was correct. That young black man never said the police reports are true. But if that transcript had stood as it was, and he tried to sue the police in federal court, it would have protected them from civil liability. I am not here today saying that that court reporter is responsible. I think court reporters get leaned on just like judges lean on judges and lean on lawyers. But someone has to stop the madness. Someone has to be able to stand up and speak out. This body should be particularly concerned when judges are essentially breaking the tripartite, stepping out of their role as judicial officers and legislating. And you might want to look into whether or not Hennepin County judges are meeting in secret and passing laws that govern in Hennepin County. And the last time I checked, Hennepin County had not seceded from the Union. I have a lot of documentation on that point. Now, one of the things that I have done is to work within the system, to send the smoke signals up to the appellate courts, to put things in affidavit, to track documents, get them in the record so that they can go to the Court of Appeals, so that they can do the right thing, and so that they can go to the Supreme Court of Minnesota so they can do the right thing. It is my studied opinion that that was one of the reasons that certain Hennepin County judges, judges, wanted to shut me down. I did make a complaint to the Judicial Standards Board about the Chief Judge of Hennepin County. In my opinion, they did pretty much nothing. They're very secretive about what they do, which is, I think, a problem. It seems the complainant should be told at least what's happening to the complaint, even if it's just public relations, but don't just shut the doors and leave us out of the process totally. But at any rate, it appeared that not much had been done. I had said at the bottom of my complaint, I had numerous documents in my office. Please contact me for more information. No one contacted me. But here's what I determined later happened. My complaint letter was faxed by the Judicial Standards Board office to the judge herself, who turned around to use it to make a lawyer's board complaint against me. She made 20, depending on how you count, 27 or 28 complaints against me in this same missive, clearly an attempt to take my license. Now, there's a nifty thing that state appellate law has done to lawyers in this state with regard to the First Amendment. they've decided that even if the lawyer has proof that their claim of judicial misconduct was true, such as a deposition of an eyewitness or ear witness, that the Supreme Court can make a, quote, objective determination that it's not true, and the lawyer's license can be taken. Lawyers need help from the legislature to be able to speak the truth. I will not sit here and say lawyers should lie. I abhor that. They should not be reckless, but they should be able to speak to the tribunal about the tribunal. I am one of the only lawyers I know of who is willing to take on these issues, and because of that, I have attracted a clientele specifically coming to me, telling me they're having a problem with the judge. There's only one of me. I can't handle all these cases. I don't have time to stick around for the solutions part. I have a lot of ideas. Certainly, I know that there are folks here today who have a lot of ideas for solutions. But it seems that perhaps before the solutions are considered, that there should be a fact-finding committee that can actually pore over some of these documents and look at some of these documented problems. And, in particular, start to discover whether or not, in fact, there are members of the bench who are afraid to speak out for fear of retaliation from other members of the bench. Those are the people who really know what's going on and have the inside track. And it seems to me that you might find some retired judges willing to speak out about it. Now, here's one of the interesting things, because retired judges rely a lot on a retired commission from the Supreme Court to be able to work part-time in the courts. And in fact, it has been told to me, and I do not know its accuracy, but I do not doubt its accuracy, that in fact the retired judges are told, if you don't agree to retire early so that the governor can appoint, you don't get any work as a retired judge. I think that all we can do today is talk about the tip of the iceberg. I have seen judges stand up inside the system and be unwilling to bend their own morals and ethics. And those are wonderful people, and they should be very proud. But I think that at times they get pressured. There are some positive changes. December 18, 2008, the Minnesota Supreme Court issued amended judicial standards rules. I've read them. They've been listening. They really have been listening. But we live in a system as lawyers where it is a rare opportunity to speak, so to speak, to the Supreme Court. We can't just call them up and say, hey, here's the problem. We can only speak to them through the cases that we know of. There have been some task forces of the Minnesota Supreme Court, and there have been, I think, some attempts to make the Judicial Standards Board process better. You've seen some of these public admonitions of some judges. So things are changing, and I want to acknowledge the Supreme Court for that, and I want to acknowledge the Minnesota Court of Appeals. I also want to say that the current Chief Judge of Hennepin County appears very fair and very willing to tackle these issues. The time is now. This is the time for judicial reform, and it's not just happening here. It's happening all across the country. But in order to dig our teeth in and figure out what the solutions are, it seems that we need members like yourselves of the legislature to get interested in this and to do some fact-finding and be open to solutions.
Awesome. Thank you. Thank you, Ms. Clark. I appreciate your testimony here. And the issues that you brought out, you have to leave shortly. Is that what I understand?
Well, I can stay if you want me to stay. I just wasn't on this panel for the solutions part and have plenty of work to do. So, but I will stay if you would like me to.
Well, and I wondered if we could just take a moment to have the other legislators introduce themselves here, and then perhaps if there's some questions from the legislators, we could make that available. If those don't make, speak loud.
I'll speak loud. Hi, I'm sorry I was late. I had to bill up in another committee. I'm Representative Steve Simon. I represent St. Louis Park. Thanks a lot for coming and sharing your ideas and stories.
Hi, I'm Representative Steve Raskowski. I'm from southeastern Minnesota, Wabasha, Goodhue, and Winona counties. Thank you for coming as well.
I'm Representative Dean Erdahl, and I have a committee hearing, a bill hearing yet, so hopefully I appreciate the opportunity to listen to those that I hear.
And you know, if you do have any questions for the people as they are up testifying, please feel free to do that. This, again, I'm going to say that this is not a formal condoned hearing. This is a opportunity for people to get together and hear some of the cases. And my goal on this is just what's going on here is that we would be able to hopefully identify some of these shortcomings that we have in the judicial side, some of the conflict, bring those forward, and hopefully take some legislative action to hopefully rectify some of that situation. And again, this is not a body that is going after judges per se, but hopefully we'll try and improve the system. And any questions from Ms. Clark? Okay. Thank you so much for taking the time to come this morning. And if you do have, any of the testifiers, if you do have packages that you want to leave, we'd welcome that, and we can use that as kind of a base for moving forward here.
Your Honor, I'll leave some of my cards here, and if he's an honorable, they're laughing at me. I'll leave some of my cards here. You know, my problem is I have so many documents you wouldn't have wanted me to roll a truck in here today. I mean, lawyers generate huge amounts of paper. But what I'd be happy to do is to target some areas and then reproduce copies so that it's a manageable amount of documents. The last thing I'll say is I hope that this is not viewed as a partisan issue. It seems to me very much not a partisan issue, that it should cross the aisle.
Thank you, Ms. Clark. And I would reaffirm that statement. This is not about partisanship, Democrat or Republican. This is about good government. This is about, in my particular interest in this issue, is there's always room for improvement, and my immediate concerns are that we have a responsibility under Article 6, Section 9 of the Constitution that the legislature has the authority for oversight for misconduct and issues dealing with the judicial branch. And my concerns would be that the legislature has somewhat abdicated that responsibility, and that's what we're here to talk a little bit about today. At this point, we've got Sergeant Westfall. If you'd please introduce yourself and go ahead with your testimony, Sergeant.
I'm Christopher Westfall. I was active duty Air Force for 12 years, and now I'm in the Air Force Reserve because I lost my active duty job due to judicial misconduct. The letter I'm about to read you was dated November 2nd, 2004, addressed to the court and submitted as evidence. Please be advised, Tech Sergeant Westfall is not authorized to obtain outside employment due to mission requirements and the squadron being below authorized manning levels. Tech Sergeant Westfall submitted a request to be allowed to maintain a second job. His request is denied, and I have been asked to provide this letter to the court as documentation as such, signed by my commander. In 2005, the trial court said that husband testified that he was prevented by a lawful military order from working a second job. The district court found the husband failed to provide any evidence that the Air Force was preventing him from working a second job and imputed income to the husband. I don't know how to be much more clear than that.
Sergeant Westfall, could you give a little background on the instances? Was there a judgment that was set against you in terms of the earnings that you were getting on a monthly basis that precipitated some of this process?
I've never in my life earned what they imputed. I'd be driving a nicer car, living in a nicer home. The court found that I could earn $6,280 per month. At the time of that judgment, my W-2 shows I earned a total of $33,632 that year. That's with the second job. So my child support was set at $45,265 a year on an income of $33,632 a year.
With the second job?
Yeah.
And you just said in your testimony that your commanding officer said you could not maintain that second job, is that correct?
Correct, and I'll provide you a copy of that letter. Okay. It's right here. The judge saw it, I saw it. Well, anyway, the Court of Appeals decided that this judge abused her discretion and overturned that. Prior to that happening, the final bill I got from the child support worker before the appellate court verdict had me $104,000 in arrearages. which caused the revocation of my security clearance, which caused the termination of my employment. I don't know how many times I testified, sent letters. I don't know how to make it more plain. I'm in the military. Anybody can go on the internet and look up what an E6 makes with 12 years of service. Google it. So I knew that it would get corrected. It did. Problem is, I'd say $23,000 in attorney's fees to get that judgment and $55,000 in attorney's fees to correct it. It's mind-numbing. I don't know how it happened. I don't know why it was allowed to happen. I talked to the county, I talked to the state, I talked to anyone I could, and they all just kept telling me, we don't get involved. Thanks for serving your country. And it kind of dawned on me, on top of all that, when I was reading the divorce decree, the judge also found, after I was $104,000 in arrears, that I should pay my ex-wife's attorney's fees of $23,912. Okay? But thank goodness the Court of Appeals said, we find no basis in the record for concluding the husband had the ability to pay wife's attorney's fees, and denied it. But you got to understand, the appellate court read the same exact file the judge read when she made that finding. So you have a district court referee, I won't call her a judge because she wasn't, who said, here's a guy who makes $33,000 a year, serving this country. I think you should pay $45,000 in child support. That doesn't even come close to factoring that I have to pay rent. I have to buy food. I have to have a car. I have to have a certain standard of living.
Could I ask a question here at this point? Just when you say that the judge ruled that you had to pay $45,000 in child support, he's saying that you had to pay your child support based on making $45,000. Is that correct?
No, sir. The judge found, or the referee found, that I was capable of earning $6,280 per month in 2004. So in 2004, my W-2 quite clearly states $33,632.40. But if you add up, it says right here, the court found the husband is capable of earning $6,280 per month in order to pay the wife a total of $3,772 per month. If you times that by 12, it's $45,000. That exceeds my income by 12. And I went to the county, I went to the state, I tried calling the governor, I did everything in my power, and nothing mattered. It was, well, it's not our problem. File an appeal. Okay? So with the negative $12,000 I have left, how am I supposed to do that? As noble as some attorneys are, they don't typically want to work for free. It's upsetting. It bankrupted not only me, it bankrupted my ex-wife. We have 4 children together. That this money that got spent to get this result could have paid for their education, a better standard of living. It didn't. That money's gone. And I spoke to my ex-wife recently, and she stated she owes her attorney over $70,000. And I owe mine close to that. So between the two of us, just in legal fees, we have over $140,000 in debt. She works as an accountant, and I work in the United States Air Force. It's unheard of.
And Sergeant, if I could, just as the determination was made and the case went forward, the district court judge reviewed the case that the referee had made the determination on. Is that correct?
Correct.
Can you give us a time frame on the amount of time it took from the time that the decision was made at the referee's site till it went through the district court, at the time it went through the appellate process, and did this go before the Board of Judicial Standards as well?
Yes, the Board of Judicial Standards found that the referee did nothing wrong. I pointed out to them that she was making donations to my ex-wife's attorney's firm. Found it around the internet, and they said that's okay. So,
Excuse me, Sergeant, when you say contributions or donations, tell us more about that.
there's my ex-wife's first attorney, Jennifer Marachek, works for I can't remember if it's a Southern Association. It's I can't remember the exact name of it, but it's Smurls. And if you go on the Smurls website and look at their their donations, they list them by year. You'll find referee Mary Ellen McGinnis's name as a donor. I thought that was kind of interesting because she did donate to Mark Olson's attorneys. I don't know what that means. I just know that particular attorney got this initial judgment. It's kind of an interesting coincidence. So I simply know this, that if I made $6,280 per month ever in my life, that would be reflected in the audit the county does. When they went to the appellate court, the county was ordered to do an audit of all my tax. They went to the IRS. They had to pull all these records. Not even close. Not even close. The most I ever made was $4,400 a month.
And sorry, could I go back to the timeline that we're talking about here between the decision by the referee to the district court to the Board on Judicial Standards and then to the appellate court?
The initial order that ordered that amount was in 2004. The divorce decree was signed December 31st of 2005, and the appellate court decision came out April 15th of 2008.
And at what point did you appeal to the Board on Judicial Standards?
3 separate times, 2004, 2005, and 2006. And then I just gave up. It's pointless. It's, in my opinion, I don't know if it's that they're pointless or if it's the rules that they. Some people I talked to seem empathetic, but basically said if the judge didn't, they just don't have any say over a judge saying. Because basically, according to them, she could have said I could earn $10,000 a month. That's fine, but their attitude is, well, appeal it. I'm just trying to make you all understand that that's not free. To file an appeal is expensive, very expensive, and I'll be paying that off well into my golden years. So the fact of the matter is, it shouldn't have happened. And the simple fact is, like anyone else who's ever been through a divorce, you have to submit your pay stubs to the court. I did that. You have to submit your tax returns to the court. I did that. You have to submit your W-2s to the court. I did that. And somehow, out of my $33,000, this judge said, well, I see $6,200 a month. It's unreal. It's something that I hope that out of this committee someday, that something as simple as an income determination, that they can never do that again to anybody, and just look at you and say, well, you're a good guy, I think you could earn $7,000 a month. Fact is, you can't. Fact is, when I was working a second job, I was living in the home with my ex-wife. Well, now I'm not. Now I'm living in my own home, and I have every other weekend visitation. I was working my second job on the weekends. This is simple math, people. Even if I was able to work a second job, what am I supposed to do? Refuse to see my children? So I can satisfy a judge's, I don't know what her agenda was. I, to this day, don't want to know. But what separates me from her, I'll tell you this right now, is I would die for that woman tomorrow if asked to. And doesn't make me very happy. That's the oath I took. And for my trouble, I was treated subhuman. Absolutely subhuman.
Yeah, go ahead.
Sergeant, can you tell us a little bit where you are now, if your child support payments are in line with your income, and then I'm also curious, and this will show my ignorance of what I know for sure. They tell us in the legislature never to ask a question unless you already know the answer. I don't know the answer to this one, but I'm guessing that as a result of the loss of your security clearance, you had a loss of income as well. I'm assuming that somebody with a security income has the ability to make more money in the service, and so were you able to calculate your loss of income as a result of the loss of security?
There was no loss of income per se because I was able to find a job in the Air Force Reserve. And when the appellate court verdict came down, the Air Force Reserve saw that and everything had been reversed. So my child support went from $3,700 a month to $1,523 a month, which is exactly what it should be and what should have been all along. So I have no arrearages now. They garnish it right from my paycheck. Perfect. So where the loss of income comes in, and where my ex-wife and children lose, is I was made ineligible for promotion. Can I be promoted without security clearance? So I was not allowed to test for the rank of E7. So the rank of E7 is $1,000 a month more in income, and they just don't get it. So, and I could have told more people what they were doing to me. So instead of keeping me in court for the last 4 years, it got turned on to me that I was the one doing it. Well, I don't know how that's possible. If you would have been fair in the first place and just said, an E6 in the military only makes this much, child support is set at that amount. But it didn't matter. It was, well, but I have this, and I need this, and I need... I don't think that people understand. When you split a home, you have one family paying one mortgage. Makes perfect sense. Then you take one person out, which is 99% going to be the father. There's nothing. It goes on his back. Guess what? He has to buy a bed. He has to buy dishes. He has to buy... I mean, it's unreal. It doesn't get factored in. I didn't just get kicked out of my house and my ex-wife said, well, here's a couch, here's half of our bed, here's all the pots and... I didn't get anything. I got nothing. I got a pillow and some clothing. A couple Air Force awards, nothing else. And with that, I'm supposed to rebuild my life. Seems very fair to me.
If I might, are you now able to take this test and move towards having an E7 clearance? Or,
yes.
I mean,
well, that's all been...
It seems to me that you've been damaged quite a lot as a result
financially,
of this.
mortally, it's unbelievable. I couldn't get a credit card if I wanted to. All of that debt I read you about earlier, the back, all that child support debt was on my credit report for 3 years. You want to know what people say to, me and my wife went to buy a house in Rosemount, and the mortgage officer looked at me like I was a scum of the earth. He pulled my credit, was like, you owe how much in child support, you piece of... Oh, there you go. Perception's an interesting thing. The Air Force Reserve is fine because I have my security clearance. I can only tell you this, the last year in the Air Force that I spent active duty, I spent at least 1 day a week in my commander's office hearing not so nice things about myself.
If I might, I'm still not clear. For a period of time, because of this whole mess, you said you were unable to, that you lost your security clearance. I'm assuming there was a loss of income as a result of that.
There wasn't.
There wasn't?
No, what happened was they said, you lost your security clearance, you have 8 months to find another job or get out of the Air Force. Okay. In that meantime, the appellate court verdict came out, fixed everything, but it was too late. The Air Force isn't going to let me stay in now because they already had filled my billet. I was already slated to leave. Someone else was already slated to come in. I have to go. So now I was left with, what do I do? So I went to the Air Force Reserve and they hired me. So there was no loss of income. However, if I wasn't able to find that job in the Air Force Reserve, then of course there would have been. It would have been catastrophic.
And at this point, are you able to test for that E7?
Correct, I am now. That will happen in a couple of years. The final thing that I'll talk about before I leave is being in the military, I have certain protections from the federal government, Soldiers and Sailors Relief Act. I had filed that motion. I was not able to attend my final divorce hearing to work requirements. I was the only person at work. Everyone else was sent away and left me there by myself.
Okay.
So the court was notified and said that they declined to afford me my rights. But that decision is not theirs. The law was amended by President Bush in 2004. And the old law had stated that it was up to the court to determine if a stay was to be granted. The new law said a court must grant a stay for at least 90 days upon request. Didn't matter. So I'll just tell you this. I got half of nothing. I got nothing out of the sale of my home. I got no property from the home. I got nothing. All I got was debt. So that happened because the judge said I didn't show up. So my ex-wife gets what she wants. It's a default, in a sense. But I couldn't show up. The judge was told I couldn't be there. This seemed to perplex even the appellate court. Well, how do we know the person who signed the letter was his commanding officer? My lawyer's argument to that was, well, really, his commanding officer is the president. A letter from him? I mean, they will always find an angle. Bottom line is, I'm not here to complain to anybody. I am very, very, very happy. The one thing the court cannot take is who I am. They will never get near that. I've seen it take other people down. I couldn't be happier, everybody. I mean that, sincerely. I have a beautiful wife. I have 4 beautiful children. I have a relationship with my ex-wife now. That wasn't possible 4 years ago. It took this experience to open people's eyes. And the bottom line is, I'm not alone. My story, I'm sure there's worse. But nonetheless, my story is true. I didn't talk about my opinions today. I talked about what I have in the file, what's on paper. I'm going to survive this. It has a lot to do with the military. The training you get kind of numbs you of these things. I've seen worse things in 14 years. Not everyone has that coping mechanism. I think that when you look at the totality of that, and you maybe in a quiet moment think to yourself, what would happen if you went home tonight? I told you you could never come back and see your wife or children ever again until some judge said you could. How that would make you feel. And then start to apply that to the people you know. Some people fly off the handle. Some people start to wonder, there's cause and effect to this. I'm thankful for the support of my father, who's here today. His late 60s, should be retired, and unfortunately he's been helping me pay the rent for the last 4 years. Kimley, Troy Moldy, Representative Severson, tremendous moral support. Without it, I don't think I'd still be in the Air Force Reserve. Because, quite honestly, you get to the point we don't want to work anymore. I don't want to work for free either. It's selfish, but I work hard. So, thankfully, the Court of Appeal saw reason. It's $55,000 more that I had to mortgage myself into to obtain. I just see this as being such a simple matter. I never had the ability to earn that kind of money. And even if I did, I was giving my ex-wife $4,000 of that $6,200. How the heck am I supposed to pay for that? It's just not conceivable.
Appreciate your testimony, Sergeant, and you've got the paperwork statements there if you'll make those available as well. And I think the next person I've got testifying